Hello, I'm Professor Nancy Levitt, and we're going to talk torts. In the previous video, Professor Duncan gave an overview of the first-year curriculum. Here we focus on just one of the first-year courses to give you a sense of how to approach a course and analyze the elements of a cause of action. As in the book version of One Hell of a Ride, we selected torts as our sample course. I'm not here to teach you the entire body of tort law in 10 minutes. That would be turbo torts, but to suggest ways to approach a primary substantive area. And the approaches that we talk about should extend to other courses, such as property, contracts, or criminal law. The same set of facts, a good bar fight, for example, can give rise to both civil and criminal actions. The civil tort claim for battery is brought by the private plaintiff in the bar fight. The criminal action for battery, although probably defined differently, is brought by a state prosecutor or district attorney. The civil and criminal cases can proceed at the same time or consecutively, but they'll most likely be in different courtrooms with different judges. Which gets filed first can simply be a matter of strategy. A tort is a civil wrong, other than a breach of contract, for which the law provides a remedy, usually in the form of damages, or at times an injunction or stop that order. There can be many separate tort causes of action, from products liability to defamation to negligence. You're probably familiar with lots of different types of tort cases. Car accidents, asbestos causing cancer, school bullying, the McDonald's coffee is hot case. Let's step back and look at the big picture of tort theories. Torts cases are often put in categories depending on the mental state of the defendant, ranging from intentional torts to strict liability. Consider this breakdown. The easiest way to think about intentional torts is to think about acts done on purpose, like fraud or conversion, the civil equivalent of theft. Negligence is a lack of reasonable care or unreasonably risky conduct. Strict liability is liability without fault. Examples might be vicarious liability, an employer's responsibility for the on-the-job torts of an employee, or liability based on dealing with hazardous materials, even if the defendant has handled them very carefully. Let's talk about the first two of these categories, intentional torts and negligence. The basic common law intentional torts are battery, assault, false imprisonment, intentional infliction of emotional distress, trespass to land, trespass to chattels, and conversion. Let's take one intentional tort as an example, define it or figure out its elements, and walk through how the plaintiff would prove a case. This is called element analysis, and it's not just a torts trick. No matter the course, you should break claims and defenses into their component parts and see if the party with the burden of proof has proven all the elements. A battery is defined in tort law as the intentional infliction of harmful or offensive bodily contact. Here are the elements. In most civil cases, the burden of proof is on the plaintiff to prove the elements by a preponderance of the evidence, which means the plaintiff must show that it's more likely than not that each of the elements is satisfied. This burden of proof in most tort cases differs from the burden of proof in criminal cases, which you TV legal drama junkies will know is proof beyond a reasonable doubt. Let's apply the battery definition to a specific set of facts. Remember that bar fight we were watching? Assume that after words are exchanged, Evan hauls off and hits Mike on the jaw and breaks his jaw. Evan had a purpose or intent to inflict a harmful contact. His fighting words are good evidence of his purpose, as is his hitting Mike on the jaw. The resulting contact was harmful, the broken jaw. Each of the elements is met. Notice how we took each element one at a time and used what scant facts we have to show that each element is satisfied. This is where the points are, in exams and in life. Conclusory statements such as, Evan committed a battery on Mike, get the most minimal points. Show your reasoning. Use the facts to show how each element is met. But that's just the plaintiff's side. Defendants often have defenses on which they have the burden of proof. And they may also have their own case or counterclaims. As for independent defenses, if this were a professional fight, Evan is Evander Holyfield and Mike is Mike Tyson, the parties may have agreed up front or consented to the batteries. But there are limits to defenses. Evander might not have consented to ear biting. Let's briefly work through a second defense. The more defenses, the merrier the defendant. The second defense is self-defense. People are allowed to use a reasonable amount of force when it appears reasonably necessary to prevent an impending attack. Here are the elements of the defense. We would need to know more facts to walk through the elements of who attacked first and with what amount of force and whether an ongoing threat was still present to know whether Mike can argue self-defense. The important takeaway for you to keep in mind is that defenses have elements too. Let's shift now from intentional torts to negligence. You'll probably spend 2/3 of your time in torts on negligence claims. Negligence is much fuzzier than intentional torts, mainly because negligence law centers on the word reasonable. People are expected to act reasonably under the circumstances to protect others from risks that their conduct creates. But reasonable people can and do disagree on what's reasonable conduct. Moreover, what's reasonable or unreasonable can change with the circumstances. This puzzle can drive both law students and judges crazy. You can break negligence torts into elements too. A negligence claim requires 4 elements: duty, breach of duty, causation, and damages. A duty is an obligation to protect other people against unreasonable risks. Duties often come from relationships, innkeeper-guest, or employer-employee, or from taking actions that create risks, say, driving a car in a dangerous way. There is rarely liability from inactivity among strangers. For instance, in American law, you don't have a duty to prevent blind strangers from walking into traffic. It's morally corrupt, but it's not tortious to fail to stop them from hurting themselves. The breach of a duty is typically the failure to exercise reasonable care under the circumstances. How do courts evaluate whether conduct is unreasonably risky? They compare the risks of the defendant's conduct to its benefits. They weigh risks against utilities. Negligence cases have to cause damages. There has to be actual harm, economic loss, or an injury. So when you saw that crazy driver weaving toward you, the one who came within inches of hitting you, that might have been dangerous driving, but it did not cause actual damages. The 4th element of the negligence package is causation. It has 2 subparts, and both are required. First, the defendant's negligent behavior or breach of duty has to be the but-for cause, or cause in fact, of the plaintiff's damages, a causal connection between the defendant's conduct and the injury to the plaintiff. Remember Professor McClurg's kind of crazy hypothetical with the school bus full of alphabetical children? But-for causation casts too wide a net of potential liability. That's the policy limit of the second part of causation. The defendant's negligent behavior must be the proximate cause of the plaintiff's damages. The general idea with proximate cause is that the plaintiff's injuries have to be foreseeable, or else the defendant can't see them coming and shouldn't be liable for them. But that's oversimplifying a fairly complex area of law and policy. So we've seen the 4 elements in the negligence package. The defendant will want to raise independent defenses. In a negligence case, the 2 main independent defenses are assumption of risk and contributory negligence, or comparative fault. Assumption of risk is the negligence equivalent of consent. It's the agreement up front to voluntarily encounter known risks, like sitting in an unscreened area during a baseball game and catching a foul ball in the teeth. While assumption of risk is consent-based, Contributory negligence is fault-based. Two drivers, for example, can both be at fault in car crashes. Contributory negligence used to be an all-or-nothing defense, totally barring a plaintiff who was even minimally at fault herself. Now the vast majority of states have what are called comparative fault systems to allow juries to award damages in proportion to the party's fault in the occurrence. In this one-hell-of-a-ride condensed version of torts, we've covered intentional torts and negligence. As you might imagine, we've barely scratched the surface of a fundamental course that all first-year law students will take. The point has been to combine a big-picture view of the law of torts with the ideas of element analysis, burdens of proof, and claims and defenses. Thank you for listening. You can test your comprehension of this module by taking the brief self-assessment test.